Hello, everybody. This is Dr. Cole. It's Sunday afternoon, November 3rd, and this will be the announcement for Week 12 of Political Science 3753 Con Law for the fall 2024 term. Everyone, we're going to take Quiz 5 on Tuesday, Election Day, Tuesday, November 5th. You have two articles to read going back to what we were looking at last week with freedom of speech. You have an article by law professor Tim Wu of Columbia University, I believe, who expresses the view that we've perhaps gone too far with First Amendment rights in some respects. Then you have another article by Jacob Sullum responding to and criticizing the views of Tim Wu. So look at those two articles, and you have a total of 10 true-false items on those two articles combined. Okay, 15 minutes for the quiz, anytime on Tuesday, Election Day, November 5th. Okay, look at the article by Tim Wu and the one responding to that article by Jacob Sullum. That'll be our fifth quiz on Tuesday, November 5th. After that, everybody, we'll try to get in a quiz and a discussion before Thanksgiving, and then another quiz and another discussion the last week of the regular term after Thanksgiving. And that will give us 7 quizzes and 7 discussions with any luck by the end of the term. Okay, what we have this week on the syllabus is freedom of the press. Let me go through and hit some of the highlights of what we'll be looking at on freedom of the press in the class notes for lectures 21 and 22. Everyone be familiar with the trial of John Peter Zenger going back to the year 1735, decades before the Declaration of Independence and the Revolutionary War. In spite of that early date, is regarded as an important case in the evolution of freedom of press in the United States. Because the British authorities at the time, both in the colonies and Britain, publishers could be prosecuted for seditious libel, libel against the government or the crown or the monarch. And it didn't matter whether the statements were true or not. If they were regarded as seditious, you could be put on trial. Okay. Now, what happened was publisher John Peter Zenger, publisher of a New York City newspaper, was put on trial, and in effect, what happened was the jury exercised jury nullification. Okay. They did not accept the doctrine of seditious libel. And furthermore, they regarded truth as a defense. Okay, if the statements made were true, that should be relevant to the defense of the person being put on trial for libel. As a result, the doctrine of seditious libel did not catch on in the United States. Okay, we established a fairly firm tradition of no prior restraint on publication, and that truth is a defense against being prosecuted for a publication. Okay, some important precedents in press freedom. Nearer versus Minnesota, 1931. That's the case in which the provisions of the First Amendment were applied by means of the 14th Amendment to the states as well as the feds. Okay, we have a series of cases, under that doctrine of incorporation that extends protections, even though the First Amendment says Congress shall make no law. A series of decisions extended all those protections by means of the 14th Amendment to the state, to apply to the states as well as the feds. And it's Near versus Minnesota, 1931, that extends freedom of the press protections to protect it against state governments as well as the feds. Later cases, going back to the 1970s, the Stanford Daily case was a case in which a photographer at the Stanford University student newspaper had taken photographs at a protest that the authorities thought were evidence of a crime. The Supreme Court held that the premises of the Stanford Daily could be searched. Subsequent to that, Congress passed legislation giving publishers protection from being searched, further protection than they'd been extended in the Stanford Daily case. authorities had to use a subpoena rather than a search warrant. Okay, so under a subpoena, the publisher can produce particular things rather than having their whole premises ransacked. The Pentagon Papers case from 1971, those who are old enough may remember the name Daniel Ellsberg, who released to a New York Times supporter volumes of documents that were really supposed to have been classified, but the Supreme Court ruled that the Nixon administration was not entitled to see prior restraint of publications of stories in the New York Times based on those publications. Libel and obscenity are covered in the class notes for Lecture 22. Everybody keep in mind an important precedent going back before the Pentagon Papers case is the case of New York Times versus Sullivan, 1964, which involved an attempt, I believe, to prosecute officials of the NAACP for libel. Okay. Justice Clarence Thomas has expressed dissatisfaction with New York Times versus Sullivan. He thinks it should be easier to get a libel judgment. So if his views prevail, New York Times versus Sullivan could be reviewed and perhaps revised or even overturned at some point in the future. But for the moment, that remains the main Supreme Court precedent on libel law in U.S. constitutional law. New York Times versus Sullivan, 1964. Now everybody, the court has held that public figures, and who is a public figure is subject to some interpretation, public figures are entitled to less protection than private individuals because public figures, the court argued, have other ways of responding and protecting their reputation that private individuals do not. Okay. To win a libel judgment, a public figure has to prove actual malice, which means on the part of the publisher or the individual making the statement that's allegedly libelous, it has to have been either knowingly false, the individual making the statement had to know it was false, or either acted with reckless disregard of whether it was false or not. Okay, so that's a lower standard for finding a libel judgment than would apply to a private individual. So keep in mind the doctrine of actual malice as it would apply to a public figure. On obscenity, the courts have been criticized for being all over the map on the issue of obscenity. In a 1964 case, Jacobellis versus Ohio, Justice Potter Stewart made the famous statement about hardcore pornography, "I know it when I see it." The prevailing precedent for what constitutes obscenity is Miller versus California in 1973, but much of the terminology that the court used in that decision is ambiguous and open to interpretation. Okay. So for an example of that, just Google on the term prurient, as in prurient interest, which is one of the phrases that the Supreme Court used in that decision. One very, very clear doctrine, however, is that child pornography is entitled to much less protection. Okay, so you'll read about at the very end of those class notes in Lecture 22, the distinction between pornography in general and child pornography. Okay, everybody, that is it for Freedom of the Press. Okay. Quiz on Tuesday, quiz 5, on a couple of articles you've been assigned, going back to what we talked about last week on freedom of speech and First Amendment issues. So we hope you'll take a look at that material and answer the 10 true-false items sometime on Tuesday, anytime during those 24 hours. 10 items, 2 points each, 15 minutes to take the quiz, and we'll be talking to you once again about a week from now at this time.